Thank you both very much. All right. Next case on the docket is WEINREICH versus HACKLEY. Okay, you may proceed.
Good afternoon, judges. Richard D'Amico, Ormond Beach, Florida, representing the appellant, Stephen WEINREICH. The essential facts are really fairly brief. The parties entered into a marital settlement agreement in February of 2003. On March 10th, they signed an addendum to that agreement, and the addendum contains a provision that says that if there are any back taxes that are accrued during the marriage, the parties will share those back taxes equally. Final judgment was entered on March 21st of 2003. Subsequent to the final judgment, an inventory problem, which had been festering for many years, finally came to a head. And it was explained to me this way, that if you have inventory and you sell it and you make a profit on the inventory, you then buy new inventory with the profit. But at the end of the year, you don't have enough money to pay the tax on your original profit, and you're sitting with a warehouse full of inventory. That's what happened in this case. But you still owe the tax on the inventory that you sold. And Mr. WEINREICH didn't declare that tax, and he didn't for a number of years, and it accumulated. When a new accountant took over, he said, "You've got to get this tax paid." And so what he did was he started paying it over a certain time period. It's all shown in, matter of fact, there's a chart that was done by the accountant that showed how he paid back that inventory. All of this accrued.
Well, at the time the addendum was executed, didn't you basically know how much was owed and back taxes, or how much he had not reported and how much he owed?
Actually, no one calculated it. No one had done
Well, it was
anything.
calculable, wasn't it? I mean, you could have found out at that time.
It could have been. I guess it could have been, yes.
Well, it was 7 years later that he actually tried to collect her share of it. What took so long?
Correct. Well, I think he was waiting to pay it all back. He also had pay it back to the IRS.
What does that have to do with it? I mean, at the time the addendum was executed, he knew that there were taxes that were owed. He could have calculated how much they were, yet he waited 7 years until he owed the final installment to her to try and use that as a set-off.
Correct.
So what is that the reason? I mean, he didn't.
I mean, that could have been a reason, but there's no requirement in the agreement as to when it does get paid. It's when the taxes were paid over a time period.
Were those taxes ever declared in the filings to be related to the years of the marriage?
Well, that was borne out in the testimony and from the accountant. But
when he was paying these taxes 3 or 4 or 5 years later, was he telling the IRS, "I owe this tax from 5 years ago," or was he just including it on this year's tax?
He was adding it on to the tax, and I don't know if there's a way that you can do that. He did file a
Somebody
form.
indicated they could have filed amended tax returns and attached it to the year they claimed it was due, right?
Right. If that had been done, it would have been a devastating event, because the tax would probably have been double, because then there would have been interest from, it would have been astronomical.
But it probably would have been what the Internal Revenue Code called for, right?
Well, his accountant and the other expert disagreed on this. Our accountant said there is a plan where you can repay this over a 4-year period.
Didn't that provision require there to be a change of accounting in order to use that 4-year plan?
Well, his explanation of it was different than the other expert as far as how that accrual basis worked. But the fact was, these taxes were owed, and they were paid back. And now, understand, this is something that our client paid. He voluntarily paid. He owed these taxes. He should have paid them a long time ago. There's no question about that. But when he signed this agreement, and when the wife signed this agreement, it specifically says that taxes back, it calls them specifically taxes, back taxes, that accrued during the marriage shall be divided equally. This, I mean, had it all come out.
It also seems to indicate that it would be paid, at that point in time, rather than him waiting 7 years later to try and collect it as a set-off against what he owed her. I mean, it seems to me like that's what the addendum was basically saying.
I don't think it
He
says
wait-
that. It says that, I mean, it could have, I mean, it's theoretically possible it could have happened 5 or 6, 10 years later.
Wasn't that the intent of the addendum for her to pay the share of the back taxes at the time the dissolution took place, and to have it all settled then and there? And then he waited 7 years later to try and collect it when he owed her money?
I don't see it in there.
Well, I mean, it's not specifically in there,
Yeah.
but I mean, wasn't that basically the intent of the parties, to have it settled then and there and to have it over with, rather than to have him wait 7 years or 5 years or 4 years or whatever it was?
Well, that was to her benefit to pay it later, it would seem to me. And he was delaying this tax bill. And the testimony at the hearing was that the taxes weren't paid because he didn't have the money at the time. And then when he had some good years, that's when he beefed up this inventory and he paid it. I mean, it is a tax due. Now, whether he delayed in making the claim, I agree, he did. But there's nothing in the agreement that would stop him from doing that. And had he done it sooner, then, assuming the former wife owes the money, she would have had to pay it a lot sooner. And then he would have had some big lump sum payment that he probably couldn't make. If you look on the chart that we have attached, you'll see that there was so much paid each year, so much tax toward that inventory. And now it's down to, quite a bit
But
less.
that didn't affect what he was claiming her share of it to be, though. I mean, her share was supposed to be half of what was owed and it wasn't paid.
Correct.
Whether he was paying incrementally in
Correct.
subsequent years wouldn't affect what she actually owed as a lump sum for part of the debt, would it?
Well, it was calculated with the total amount of the debt that was related to the inventory that had accrued prior to the marriage, and then what the tax was on it, and her obligation was half of that. That's what was claimed at the hearing. The total was $79,000, so half of that would put you at like $39,500. I just want to address briefly, the trial court actually set forth reasons for her denial, and we addressed each one of them in the brief, but the first one was that the settlement agreement reflected an agreement of $333,000 final settlement, and that's true. That was what the agreement was. But a month later, or a few weeks later, the parties then entered into this supplemental amendment, and the amendment basically said that while we agreed on this, there may be some tax liabilities that come forth later, and those are going to be adjusted. And if you think about it, equitable distribution, if this tax had been due at the time, it would have reduced the value of this asset. And then, when you equitably distributed it, she would have gotten less at that point. So the first reason really...
Who got the asset of the business?
I'm sorry?
Who got the asset that was the business?
He got the asset, but he paid her for it, a lump sum, in the agreement. $330,000 was the payment for the business. But again, that agreement was a few weeks before this amendment, and the amendment was signed and said that they would adjust any taxes due after that accrued during the marriage. And that's essentially the second argument that the judge set forth was something about this not accruing, but the fact is that these taxes did accrue. The evidence on the record was from just about everybody. The tax returns were put into evidence. The inventory, which the wife had actually participated in preparing, the two account...
Did the tax returns that were put into evidence show that this tax was accrued during the years of the marriage?
Well, that was based upon the accountant's testimony, my client's testimony, and the tax returns themselves show an increase in the inventory other than what the inventory really was. I don't think there was really a dispute on that issue as to that this was... He paid that tax from years prior. The accountant specifically, he had the exact figure of how much was owed through that year 2002. And, well, the final issue was that the judge talked about that the addendum did not relate to Total Entertainment, which is the corporation, but the corporation was a Subchapter S corporation. As a Subchapter S corporation, all the income flows right through to the individual, just like as if it was an individual. So the taxes that were owed on this are individual taxes, not corporate taxes.
Was there also an unclean hands basis or defense?
I don't know that it has anything to do with it, with this issue.
That was pled in the trial court, though, wasn't it?
It was argued, not using the words unclean
You're claiming a
hands.
set-off, which is an equitable defense, so wasn't that raised in the trial court?
I don't know if this is so much an
Trial court,
equitable...
I don't think the trial judge really got to it. But.
No. Well, basically, because what they said was that our client did not declare this inventory. He didn't, okay? But that doesn't mean that he's, some kind of a criminal. He's a businessman, and he did pay it.
Aren't you some kind of a criminal if you don't declare income on your income tax returns that you're supposed to?
But he tried to correct it, is what he did. He corrected it later. It was a business problem. But does that mean that this agreement then becomes ignored? I don't think that's what the agreement of the parties ever was. Really, it shouldn't. There is one case, by the way, that I cited, which has a lot of similarities. Obviously, this is not your standard set of facts, but the case of Branch v. Branch that we cited was a case where a husband invested money into a failing business, and he owed the IRS $90,000, half of which was penalties. And the court found that it was twice the amount of the lien had accrued because of his non-payment, and it was from a business that generated income which he failed to apply to pay off the tax lien. The former wife had no control over the non-payment of the lien, and the court said it doesn't matter. This is a marital obligation, and irrespective of the fact that he didn't pay it or that she had no control over it, it's still something that is an obligation. And they actually reversed the trial court on this, and they said that there's no showing that the funds were diverted to some improper use. And in this case, it's pretty much uncontroverted that this guy was operating a business, and he was short in the payment of those taxes, so therefore, it wasn't that the money was diverted to some other source. I think that case is similar, and it is a reversal under a similar type of circumstances. The judge didn't like it, didn't want the wife to have to pay half of those tax liens, but the appellate court said that it was still a marital obligation. In this case, we have a specific agreement. I would like to reserve the remaining time if you have other questions. Thank you.
8 minutes and 22 seconds.
Hey, police and court, good afternoon. I am Douglas, Kneller. I represent the former wife, the appellee. I want to stay focused on what the issue here, and that's the addendum to the marital settlement agreement. And to do that, I think it's wise to look at the procedural posture of this case and how we came here today. The appeal filed by the appellant is several issues. First, it's the wife's motion for enforcement that started everything. Former husband was due a final payment of $25,000. He didn't pay it. There are no stipulations about that payment or anything. The wife files a motion for enforcement of that money. After the motion's filed, he then files his motion with regard to the addendum, and that's when the stipulation comes about to put the money in the trust account up to X number of weeks, and then it's distributed to the wife. So the first point of the appeal is whether the trial court was correct in granting her motion for enforcement for the former husband not paying the $25,000. And I would submit that fact's uncontroverted because the husband admitted, I had the money, I just didn't pay it. That forces the wife to file her motion for enforcement. The issue being argued today is the addendum, and the addendum is very specific. First, the issue of Total Entertainment, Inc. versus the former husband and former wife. Total Entertainment, Inc. has never been a party to this action. It has never been added as a party to the action. When the addendum was signed, it was not signed by the former husband as president of Total Entertainment, Inc. And as cited in our answer brief, I think it's reasonable if a person's going to ask for an interest of a corporation in a divorce, you have to plead corporation as a party.
It was a subchapter S corporation, wasn't it?
Yes, it was.
And it was, the stock was held by him alone, wasn't it?
Correct. It was during the dissolution, it was...
So why would you really need to bring in the corporation when it's a subchapter S and he's a sole stockholder anyway?
Because during the dissolution, it's a non-marital asset. alleged by the former husband as a non-marital asset. Now, during the tax consequence issue, all of a sudden they're joint owners of this corporation for the dissolution purpose. So why would you have to bring it in? You'd have to bring it in because if you're seeking during the dissolution to have that stock specifically issued, 50 shares to the former wife, the corporation should be a party to issue the stock.
Does a subchapter S corporation ever owe taxes? Or is it merely that the shareholders of these owe the
It is the shareholders, and that's...
So there could be no accrued taxes of total entertainment, right?
Correct.
Okay.
Correct. And it's very easy to confuse the issues here. As Accountant Myers testified, there are never any amended returns filed. First of all, for the language in the addendum, any deficiencies, taxes, back taxes, penalties, and interest from any federal, state, or local taxes that become due on any and all taxes that occurred during the marriage and up to the date of the signing of the final judgment of dissolution shall be paid 1/2 by the petitioner and 1/2 by the respondent. So how do we determine if any additional taxes ever became due? There'd have to be an amended tax return for 2002 or 2001 or 2000 or 1999. How can we possibly determine taxes that become due? There is not a tax return amended. Now, what the former husband's accountant testified, there is a method of his change of accounting. But you have to do it within a 4-year period. They admitted, when I brought that to their attention, that this has been going on for 6 years. Oh, I guess I missed that. And there actually has to be a change in accounting method. The one document that would have been educational to the court would have been the actual form that changed the accounting method. They didn't have it. The accountant didn't know where it was. I attached to my brief just as an example of what the application and change of accounting method looks like. And if you look at the tax returns filed by Total Entertainment, Inc., which were submitted to the court, specifically 2002 through 2008, which is Exhibit 1, Record 134 through 139. Schedule A, questions 9A, B, C, D, and E, and F. That's where you state the accounting method you're using. Total Entertainment, Inc. never changed their accounting method. So even if there was a change in accounting method, well, there was never a change in accounting method. So the question is,
was the opposing accountant's argument that there didn't have to be a change and you could do the 4-year plan anyway, or that there was a change of accounting and that's why they did the 4-year plan?
The opposing accountant's argument is he interpreted that, yes, that is correct. That is his argument. Which one? Accountant Bellis.
No. Which argument? I gave you 2 alternative arguments.
Okay.
Did he say there was a change of accounting and that's why we went to the 4 years, or there didn't have to be a change of accounting?
He said, well, okay. He claimed, I need to define change of accounting, how the accountant's using it and how the IRS is using it. The Accountant Bellis claims adding additional amounts in inventory is a change of accounting. So, yes to your question, a true change in accounting is whether you change the value at cost method to first in and first out method. So you cannot claim a change of accounting unless you're actually changing the method. Their accountant, Total Entertainment Inc.'s accountant, said this method is available if you just change the income. Did I answer your question?
I think so.
Okay.
So the change of accounting was they had decided to report income they should have reported before, and they hadn't bothered, and now they're going to start reporting it.
Correct, and they're trying to use that in the Form 3115. What's actually going on here?
Did you plead unclean hands?
Yes, if you look at record at...
Here's my question. I think you alluded to false financial affidavits that were filed throughout the divorce proceedings. What affidavits are you referring to?
Okay. If you look at record, there was a March 26, 2009 motion, which I believe is of the record, pages 16 through 18 has that motion in it, which was a motion to strike their cross notice of hearing. It talks about the facts alleging the unclean hands. And that's where the procedural posture of this case, again, is very relevant with regard to pleading unclean hands. This is a motion. You're not served a summons. You have to respond in 30 days. It's a motion. It's sent in the mail. There's no response. It goes on.
What are the false financial affidavits?
Okay, that's what's really going on in this case is the false financial affidavits. There are several false financial affidavits filed. Because when it was to his advantage, for example, negotiating the act of appreciation for the $330,000 payment, which also included other equitable distribution issues. When it was to his advantage, there's no inventory or assets. Or when it's to his advantage on attorney fee cost issue, there's no inventory or assets. And that comes up on the false affidavits. His February 21st, 2006 affidavit, his February 27th, 2006 affidavit, I know they're 5 days apart, his May 29th, 2007 financial affidavit, his May 2nd, 2008 financial affidavit, his May 23rd, 2008 financial affidavit.
Are you saying that they're false?
Yes, they're false because for Total Entertainment Inc. has no value at all. Total Entertainment Inc., he says, has all this inventory on his financial affidavit, on those filings. It has no value at all. He fails to put it down. And what's really going on here is when it's to his advantage not to have inventory, he doesn't report it. When it's to his advantage to use the inventory to decrease his income for child support determinations, he plays with the inventory so it affects his income on the tax returns.
Would you address the branch v. branch case?
The branch v. branch case deals with the case of equitable distribution during the dissolution. So all I can address, I don't have the branch v. branch case memorized here, but the dispute, the difference in branch in this case is branch deals with a specific debt that was specifically referred to and known. And that the wife would have had participation in. With this debt here, alleged tax debt, there's no participation by the former wife. The former husband never calls the former wife in 2003, nor does the accountant, and says, we're putting on these additional numbers. Do you agree or disagree with them? No calls in 2004, 2005, 2006. We still don't know whether these inventory numbers are correct or not. The former husband gives the information to his accountant, and his accountant puts them on the tax returns. So, again, they're just numbers that the former husband's putting on the tax returns. We would all like to say, well, gee, I don't have the money to pay my taxes this year, so I think I'll take the income I have in my law practice for this year, and I just won't talk about it for 3 years from now. That's not a proper remedy. I'd like to talk about the standard of review a bit also, because that's mentioned in both briefs. The former husband is asserting this should be a de novo review. We are asserting it should be an abuse of discretion review. We believe under either review the trial court's findings should be affirmed. The de novo review we would submit would apply to an unambiguous contract interpretation issue. We would submit that if this is a contract interpretation issue, it is very ambiguous that necessitates findings of fact with the court. And those findings of fact with the court would be specifically the amended versus non-amended tax returns, and whether whether he did it within the 4 versus 6 years, and whether there's actually a change of accounting method. So we first of all do not agree with the de novo standard review and believe it's an abuse of discretion review, because there has to be findings of facts relative to the ambiguous nature of the contract. The second issue in their brief is the former husband talks about the former wife not having substantial competent evidence on her side of the facts. I would submit to you it's the former husband that needs the substantial competent evidence on his side of the facts here, and that just does not exist. And it comes back to the simple fact of how can additional taxes be due during the marriage if there aren't amended tax returns filed, or the former wife is never notified year after year that additional taxes are due. The final issue is I'd ask the court to consider the former wife's motion for fees and costs of the appeal. We set out in our brief why we believe the former husband is responsible for it, and I would just submit to the court on the fee and cost issue that there's such a disparity between the former husband's assets and income, his being triple to the former wife, his assets being a net of $1.5 million, that if a fee and cost award is not issued to the former wife, it almost becomes a prosperity to misfortune situation for her because of the difference in the income. And she does have equity in her house, and Mr. D'Amico seems to be submitting in his brief that if she has any ability to pay, she should pay. But I look at this more as a prosperity to misfortune issue. And if that's any other questions, otherwise that's all I have.
Thank you. Okay, Mr. Miko, you've got 8 minutes and 22 seconds.
It'll be quicker than that, I hope. Just turning to a few of these issues that were raised by Mr. Neller. One of his comments was that they don't know if the numbers are correct. Well, the fact is that we supplied them with the tax returns, and their accountant just didn't look at them. They went and hired an accountant, and the first question on cross-examination was, you didn't examine any tax returns, did you? He said, no, I didn't. So, they had an expert, and their expert had the full ability to review everything. And really, they didn't attack the fact that this was a prior inventory. They only attacked the fact that, well, you couldn't maybe use this 4-year plan. You're supposed to use something else. And no matter what, our client did pay back the tax in the best way he knew how. And if you read the record, there's a substantial portion here from Mr. Bellis where he's convinced that that section that he used was the right section our client relied upon. Mr. Neller also stated something that I don't think is exactly accurate. He said that there was an argument that this business was a non-marital asset, but in the marital settlement agreement, paragraph 7A, says the parties have owned and operated a business known as Total Entertainment during the entire length of the marriage. Total Entertainment is an S corporation, and he is the sole shareholder. But she received an equitable distribution from that corporation. So there was a marital share to it. He had incorporated a little bit before the marriage. And as far as this question of false financial affidavits, what happened was during the course of other proceedings, he filed financial affidavits where he didn't put in the value of the business. It was just left blank. Now, if you want to assume that means zero, you could, but it just wasn't relevant. They were doing it was an equitable distribution at that point, so he left it out. And, I don't know that really means that much at this stage in the game. Finally, as to the fees and costs, the former Mrs. Weinreich has substantial assets, and the normal criteria at the time of divorce is different than it would be in an enforcement proceeding like this. She has very substantial assets. We listed them in our brief, and I don't think that she has the right to attorney's fees under those facts. If you look at all the case law, that she does more than have the ability to pay. She has substantial case. She just got $24,000 that's been disputed in this case. So
that really wasn't a dispute that she was owed the money.
No question.
The dispute was whether she owed him the money as a settlement.
Correct, but that's already been paid.
All right.
All right, if there are no further questions, thank you very much.